So the Supreme Court decided to grant, vacate, and remand a major Second Amendment case which deals with gun possession and nonviolent felonies. So let's talk about what just happened. Now, really quick before we jump into this video, I want to mention something new that we're going to be doing here on the channel. I'm actually going to be opening up a newsletter. Of course, we're going to be doing some news, some articles, maybe some deals here and there. But one of the main things for the newsletter is to fight back against censorship. As you guys are all aware, a lot of social media platforms do not want us to actually get access to you guys. They don't always send you my videos or other information that I'm sending out. So the newsletter is one of those ways that I can directly have communication with you all. So if you're interested, you can use the link down below in the detail section and then also in the pinned comment. It has email information that you would enter and then some other information as well. 100% of all the information will be absolutely private. It's only ever going to go to me, never to anybody else. So you can rest assured, of course, also with an attorney, that none of your information is going to get out to anybody. So again, if you're interested, links down below to the newsletter if you want to sign up. As I mentioned in the intro, in this video, we're going to be discussing a huge Second Amendment case that the Supreme Court recently granted, vacated, and remanded. This case we're going to be discussing is the Range versus Garland case, and it's a case a lot of people are very interested in because it deals with gun possession, prohibitions for someone who is subject to nonviolent felonies. This is one of those cases that's very critical because it outlines potentially how the Supreme Court should apply Bruin in that analysis and how that applies to certain issues like gun possession with people who are subject to nonviolent felonies. This case became even more important because of the recent Supreme Court decision in Rahimi. You may recall that recently the Supreme Court issued an 8-1 decision in the US versus Rahimi case, but now what they decided to do was simply to grant, vacate, and remand the Range case in light of the Rahimi decision. So we need to talk about what now happens because of that. Now, for some quick background on this case for those who are not aware, 26 years ago, Brian Range was convicted of concealing some of his income so that he could obtain additional food stamps for his family. Essentially, he made a false statement on a federal form about the amount of income he had so that he could acquire food stamps. Because of that, he was charged and convicted in Pennsylvania of a Class 1 misdemeanor. Mr. Range has no serious criminal history, no issues before or after. Simply, he just lied this one time on a federal form. He concealed his income, and therefore, because of this one ancient misdemeanor, which Pennsylvania treats as kind of a felony equivalent because of the jail sentence time, now suddenly Mr. Range forever is barred from possessing firearms. Mr. Range brought this lawsuit originally before a district court in Pennsylvania against the Attorney General and then also the ATF. And what he sought was declaratory and injunctive relief to strike down the application of 922G1 against him. He sought for the federal government to no longer be able to bar him from possessing firearms only because of that one nonviolent misdemeanor 26 years ago. However, the district court ruled in favor of the government on a motion for summary judgment. In doing so, the court used something known as the two-step approach. However, after the Supreme Court's decision in Bruin, that essentially prevents lower courts and other courts from using the two-step approach. So that analysis that they used then became invalid because of Bruin. Now, after losing at the district court level, Mr. Range appealed up to the Third Circuit Court of Appeals. And on review, a 3-judge panel in the Third Circuit issued an opinion upholding that lower court decision, and again, they cited to Bruin. The 3-judge panel cited history and tradition in finding that individuals constitutionally entitled to bear arms are only law-abiding, responsible citizens. So there, the Third Circuit 3-judge panel found that his misdemeanor, although non-violent, qualified under 922G1 and therefore excluded him from the class of the people afforded the right to keep and bear arms. Mr. Range, of course, did not quit there, and so he sought en banc panel review in the Third Circuit. And on review, the en banc panel in the Third Circuit found that 922G1, as applied to him, Mr. Range, is in fact unconstitutional. So he won at the en banc panel level. In that decision, the majority discussed how their precedent had prior incorrectly used the two-step approach, which was expressly rejected, of course, under Bruin. They also went on to say that Range's appeal instead requires us to examine who is among the people protected by the Second Amendment. Range claims he is one of the people entitled to keep and bear arms, and that our nation has no historical tradition of disarming people like him. The government responds that Mr. Range has not been one of the people since 1995, when he pled guilty in Pennsylvania State Court to making a false statement on food stamp applications, and that his disarmament is historically supported. So this is one of those really interesting cases where the issue was very clear. The debate and issue was whether or not Mr. Range and other people fall within the class of the people in the text of the Second Amendment. The state of Pennsylvania and then some other states as well say that these individuals fall outside the protection of the Second Amendment, that they're not part of the people. And then here you have the Third Circuit en banc panel say, despite what the state of Pennsylvania is saying, Mr. Range is still part of the people, even despite this one nonviolent misdemeanor. The Third Circuit en banc panel stated that in sum, we reject the government's contention that only law-abiding responsible citizens are counted among the people protected by the Second Amendment. And based on that, the Third Circuit reversed that lower court decision and ordered that the lower court issue a declaratory judgment in favor of Mr. Range. Now, in response to that decision, of course, the federal government was not going to just let that sit. They were not going to just let that fly. So they appealed up to the Supreme Court and they sought Supreme Court review on their own. But the Supreme Court recently did decide to grant review to a different case, which was the Rahimi case, which deals with a different aspect of federal law, the same 922G section, but it deals with prohibiting individuals subject to domestic violence restraining orders from being able to purchase, possess, and acquire certain firearms and ammunition. Now, the risk with, of course, the federal government seeking Supreme Court review in any of these cases is that the Supreme Court likely often does grant review to those cases. Now, we're all aware that recently Rahimi was issued by the Supreme Court. It was an 8-1 decision, essentially affirming the federal restrictions against Mr. Rahimi and other individuals who are subject to domestic violence restraining orders, that part of federal law they believe is constitutional. And there were some other issues as well in that language. The only dissenting judge was Justice Thomas, where he would have struck down that federal law. One of the issues with that language as well is that maybe they expanded the how and why analysis and were allowing maybe more analogs to be kind of blended together to come up with relatively similar historical analogs to support these type of laws. So that was one of the backdrops where Rahimi did change, I believe, some things. But you had this Range case that was on hold behind the Rahimi case. It was seeking review. The Rahimi case was not good factually for us because Mr. Rahimi is not a good person. He had a huge criminal record, and that's why the federal government really wanted review in that case and not the Range case, because the Range case and Mr. Range himself is a more sympathetic plaintiff, of course, because he has no criminal history other than this food stamp issue. He's not violent by any means. He's a nonviolent individual, and he's been barred from being able to possess and acquire firearms for 26 years only because he simply, lied or did some sort of error on a federal government form. So after the Rahimi decision was issued, that 8-1 decision, everybody had questions about what would happen with Range. Well, recently we got an order from the Supreme Court in the order list, and what they did is they decided to grant, vacate, and remand the Range case in light of the Rahimi decision. Now, a lot of us really wanted the Supreme Court to grant review to the Range case to actually review and decide the Range case on its own merits. But what they decided to do instead is GVR, or grant, vacate, remand the Range case in light of Rahimi. Now, one of the really, frustrating things about that, and one of the confusing things is, I don't think the Range outcome is going to change at all in light of Rahimi. If you look at what happened in Rahimi, it didn't change a lot specifically for the Range case. If anything, it just simply affirmed the Range case. It's, in the Rahimi case, they said that Mr. Rahimi himself was still part of the people in the text of the Second Amendment. And then they went on to do further analysis about the historical evidence of restricting certain people. And then you have this Range case where you had the Third Circuit en banc panel saying that Mr. Range also is part of the people. And that was one of the big debates between the federal government and then also the plaintiff about whether or not Mr. Range was part of the people. The Rahimi case would say, obviously, Mr. Range is part of the people, so that's kind of an open and shut case. And I would not suspect at all that the Third Circuit en banc panel is going to change their decision at all. I think they're going to once again say the same thing, say, yep, we got it right the first time, kind of take a victory lap, say, yep, the Supreme Court said that we got this right. We're going to issue pretty much the same decision once again in the Range case. And then obviously you're going to see the federal government once again go up to the Supreme Court, seek Supreme Court review, and it's going to kind of do the merry-go-round. So really, when you look at some of these GVRs, specifically in light of Rahimi, it's a little bit head-scratching to see why the Supreme Court did that. I think a big reason why they did that is to simply punt these issues. Maybe they don't want something during this next term for Second Amendment cases. Maybe they just don't want to address these issues anymore. So that's what's currently going on for those who are curious about the gun possession issues and the federal prohibitions on people who are maybe nonviolent felons. As As things change, of course, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.